and a very good afternoon to those of you joining us here for Mozilla Mornings in the afternoon, but it is of course morning somewhere, and we're very grateful to our panelists. Some of them are joining from across the Atlantic, so hence our later time slot today. We're going to be talking today about the Digital Markets Act and the key questions for Parliament. So we also have with us Andreas Schwab from the MEP from the European Parliament. But before I get to our speakers, let me hand over the floor to Regan MacDonald, the Director of Global Public Policy for Mozilla, to give us some opening words. Regan, over to you.
Thanks, Jen. Hi, everyone. Good afternoon. I hope that you've all managed to take some time off over the summer and that you're feeling refreshed and recharged for what has already been a very busy rentrée. We're delighted to welcome you to our third installment of Mozilla Mornings for this year, which today we're devoting to the Digital Markets Act. The DMA is one of the landmark regulatory proposals of this EU political mandate, and one that's been subject to intense debate in Brussels and indeed around the world. In many respects, the DMA is an early instance of a global trend. Lawmakers around the world are grappling with questions of how to enhance competition and consumer empowerment in digital markets. We can expect that the conversations we're having in Brussels today to be heard and reciprocated in conference rooms and parliament hemicycles around the world in the coming years. And today's discussion comes at a very crucial time. MEPs in the European Parliament are entering into a crunch period, and there's a real political motivation to get a Parliament negotiating position locked in before the end of this year. We're therefore delighted to be able to host, as always, a stellar set of panelists who can provide us with insight and recommendations ahead of this crucial phase in negotiation. In particular, we're honored to be joined by IMCO Committee Rapporteur, Mr. Andreas Schwab, and we look forward to hearing his perspectives and forecasts for the Parliament deliberations. We're also delighted to be joined by Vanessa Turner of BEOC and our very own co-acting General Counsel, Mika Shah. We look forward to hearing from Vanessa on how the DMA can empower consumers, and Mika will outline Mozilla's vision for how the DMA could enable a thriving, consumer-focused competitive ecosystem. I'm personally looking forward to a great discussion, and I'm sure that in an hour's time, we're all going to walk away with a better understanding and some clear recommendations for this next phase of the DMA discussions. So with that, and without further ado, I will hand it back over to Jen to kick us off.
Thank you very much, Regan, and thank you for introducing the speakers. You're doing my job, so that makes life easier because we all know what we're here to talk about and who's going to be speaking. What I will say is I do want to get questions from our audience, so there's a Q&A function at the bottom of your screen. Do use it if anything occurs to you that you really want to hear an answer on during the next hour. But with that, I'm going to hand over to Andreas. Andreas, the first question is it's a very broad one. Where do you stand now? Is the Digital Markets Act proposal still a really good idea? We've seen a lot of changes. It's been a busy first half of the year. Give me your opening thoughts.
Thank you very much, Jennifer. Thanks so much for the invitation. I think we still see that colleagues are more than convinced that the Digital Markets Act is important, and we are working very closely together already on more than 1,000 amendments to make sure that we, in the end, can find choices that we defend all together.
Okay, thank you very much. I thought you were going to say more, but that's great. Thank you. Mika, let me turn to you. Your opening thoughts, please.
Sure. Good evening to you all. As you can see, the sun is rising here in California. So I think that the DMA has a lot of potential, just like the GDPR did, to have a ripple effect around the world. But there's three stakeholders that I really think everyone needs to keep in mind in order to make sure that happens. And so the first, those are consumers, developers, and the internet. And so consumers, you and I, we should be able to use our software easily and whatever software we want. But unfortunately, that's not the case today. And so I know there's the focus is on gatekeeper behavior. And so I hope that the Parliament's position really calls this out so that gatekeepers cannot continue to use design techniques and dark patterns that disempower consumers. Similarly, developers are often disempowered by a lot of tactics. These include operating system settings and marketing tactics. And I think we all want a future where we have a thriving developer ecosystem so that there are a variety of software choices, not just big tech and not just a handful of companies over here in California. So I again hope that the DMA, when the final DMA, focuses on creating that market for developers as well. And then finally, the internet. At the end of the day, the internet is meant to be an interoperable and decentralized place. And so I hope that, I know that when we talk about interoperability, a lot of people focus on messenger interoperability, but I hope everyone is reminded at the end of the day, interoperability is really important at the broader level. And this is really needed so that we move beyond just a handful of walled gardens.
Thank you, Mika. And Vanessa, over to you. I mean, Mika mentioned there the consumers as one of the key stakeholders. Give us your perspective from BEAC.
Thank you very much, first of all, for enabling me to participate today and represent the views of consumers. Maybe just up front, for those who are not familiar with BEAC, the organisation I'm representing, BEAC, the European Consumer Organisation, acts as an umbrella group in Brussels for 46 now independent national consumer organisations in 32 countries. So that's the 27 European member states and some neighbouring countries. And our main role is to represent our members to the European institutions and to defend the interests of European consumers. So to answer your question, do we still need a DMA? I think the answer from the consumer's perspective is yes, definitely. We see that existing tools such as competition law have been insufficient on their own to deal with the challenges that are specific to digital markets. And I think we're looking back over the last few weeks, we've also seen the difficulties of dealing with the issues that are covered by the DMA in individual cases, antitrust cases, for example, around the globe, and how they, whilst they show that other areas of law are getting to grips with the issues that are at stake here, they are still too slow and reactive rather than heading off the known problems to prevent harm to consumers up front. So yes, I think we definitely need a DMA. My only caveat would be that we need to get it right, both in terms of scope and enforcement.
Well, thank you. Let's delve a little bit more then, Andreas, into your draft report. What are the bits of it that you feel the Parliament absolutely needs to stand by for trialogue? Because eventually this is what we're going to have to see the Parliament defend.
Well, I mean, first of all, we have to make a choice. What we have to do to defend the markets, open markets, fair markets, accessible markets, and where we have to regulate the business models. And the DSA, which is for the latter, and the DMA, which is for the first, have to be complementary. Secondly, this is a European law, but it's also true that member states are part of Europe and European laws as well. So we have to make sure that member states keep a strong incentive, both for the DSA and the DMA, to be monitoring, to be active, and to look a bit around, because we can fight the problems only if we fight together. And this is, I think, a crucial element on the procedure, because we want member states to legislate also in the future in areas that are close to the gatekeepers, but we want to use the power of the European Union to fight against the gatekeepers. And that's a difficult choice we have to make, how to give member states the possibility to legislate, although we have that fully harmonized approach here. Then we have to get it right, because we cannot make the internet a better place by focusing now on all problems. With the limited number of resources that the European Commission will be able to use, they have to be focusing on the biggest problems. And there's now a discussion, yeah, but should we not have a broader outreach? Well, we should have as a broad outreach as we can do with 80 people that are not as knowledgeable as the people that are sitting in the Silicon Valley. And therefore, my approach is very clearly, let's focus first on the biggest problem before we speak about normal problems. Because for sure, in the internet, there are all sorts of problems. But here with the DMA, we are focusing on the gatekeepers. And the gatekeepers are those that have one market under their control and want to use the power from this one market to leverage it into another market. And this combination, controlling one market, leveraging into the power into another one, that's the key of the DMA. Then there are some other elements around, the do's and don'ts in Article 5 and 6 that should be principle for all the biggest companies. And now is the question, for the very biggest or only for the biggest or also for the big ones? Now, at the moment, I think we should focus on the biggest problem, and the longer and the more successful we are there, the broader we can make the scope, and the broader we can make these principles respected. And then, because Mika has already mentioned the interoperability, I mean, I very strongly believe that we should not start now in the European Parliament to define what a social network is. We should not start to define business models. What we should do is to see where the gatekeepers in specific areas of business models are trying to leverage power. And there we can say minimum standards. We can set minimum standards for consumer to operate. So for example, because the messenger services example was already there, we could say there is a market for messenger services. Some of them put a high value on privacy. Some of them put a high value on cybersecurity. Others want to make them most useful. And others, again, want to use the data so that we allow consumers and users to have a minimum standard for data protection that can be used whatever form of consent has been given before, so that we give the consumers a chance to use the messenger service in a way that they can decide without any problem of consent that has been given before as a minimum standard. But at the same time, we offer specific services, still the possibility to invest more in privacy, more in cybersecurity, or more in other areas. So I think the interoperability is a very, very interesting concept. And there will be markets in the digital area where the Commission will use the power to set up behavioral remedies to make interoperability a reality. But at the moment where the diversity of business models is so big, it would be very difficult to define an interoperability standard in some sorts of services that are just new and innovative.
Vanessa, would you like to react to that and to Andreas' approach in terms of tackling the big problems first and saving the others for another day?
Sure. I think probably as I hinted in my first intervention, I agree that we should be dealing with the right things at this stage. We have this is in some ways a new law, in some ways not. We have other areas where we see regulation coinciding with competition, for example, in the telecoms or in the energy sector. But I think digital markets move very fast and they're quite complex, perhaps more complex than some of the traditional markets. So I think we have to have a good balance between over and under regulating. I mean, so far we have under regulated clearly, but we don't want to go too far in the other way. So it does make sense to me to deal with the big, very clear problems so that we don't inadvertently catch possible challenger companies within the gatekeeper definition. So yes, that I think is a good way to go. Where exactly you draw the line in terms of the criteria to catch the relevant companies, I mean, that's something that's obviously up for debate at the moment. So we'll see where that comes out. But I think in addition to that, what will be really important is to hold on to in terms of the high level key principles of the DMA, to make sure that in this regulation, to kind of preserve the raison d'etre, into my mind, of the DMA, or the key value of the DMA, is that we need to continue with the proposal that this regulation will be essentially self-executing, self-enforcing, directly applicable in relation to the Article 5 and Article 6 obligations and prohibitions. I think that's one of the key points of the regulation. Now, I think there are some loopholes to close, but that to me is one of the fundamental points.
Mika, your thoughts then on the DMA as you currently see the draft proposals. I mean, what more would you like to see? Does it go far enough? Where do you see loopholes?
Sure. So a couple of places. One on the question of interoperability. I mean, today, at the core, at the basic level, interoperability is that I should be able to use my choice of service regardless of operating system, regardless of browser, regardless of device. And this is where there's a lot of issues with interoperability, because services are designed, in particular by gatekeepers, to preference their own platforms, their own operating systems. And so expanding that doesn't need to be more than just a few words of clarification. And I don't think that it really would interfere with the diversity of business models that we have, but it would enable then, services such as, payment services offered by one gatekeeper. You should be able to use those payment services on another operating system, or music services. If I want to use Spotify or some other music service on a particular operating system that has its own affiliated service, I can't do that really well today. And that's a result of interoperability failures. And people see that through not just data portability issues, but this is actually a competition issue, which is why it's really important, I think, that competition law brings that to light. Another place where I think there could be some more clarification, and it was something that Dr. Schwab was referring to earlier, which is, what is the balance between the European Union and NRAs? And in this space in particular, I think a lot of national competition agencies have actually gone quite far in terms of understanding the markets, the problems, taking documents and doing very documented market studies and really diving deep into, from a product perspective, what is the consumer research? What is the data? What are the metrics? What is driving these decisions? And I think it would be for optimization and efficiency to have a DMA that is then not just words, but really effective. It would be great for there to be more, give and take between the NRAs and the European, between the Commission. Otherwise, what is the purpose for all of this? If every company, if the Commission with staff and resources has to start again from ground zero, that wouldn't be great for the market.
Okay, well, let's talk a little bit about overlaps then, Andres, because, in your first breath, you mentioned the DSA, and we can hardly seem to talk about the DMA without mentioning the DSA. But likewise, there's the GDPR, and as Mika mentioned, their existing competition law. Where do you see potential problems, potential difficulties?
Well, first of all, I want to tell you that we are working very constructively together with Christel Schaldemose and with the colleagues that are concerned with the DSA, and we want to avoid any probable clash that might be there. On the definitions, I think we don't have that much. On the self-executing elements, I think the DSA it's much stronger, because we want this to be a procedural law that is self-executing and gives all authorities, most of all the national authorities, a very, very good interaction to be able to act and to ban wrong content as quickly as possible, or to make sure that banning wrong content, wrong products can happen as quickly online as it has been. It has to be done offline. And on the DMA, we need to have another structure, because we need the Commission to talk to the gatekeepers, and therefore it cannot be self-executing, because we know what gatekeepers would be doing. They would declare themselves compliant from the first day on, although they are not. And it's important that we show also, because the business models are so different, they are so quickly changing, they are so innovative, that we give the companies a chance to justify their business models, to explain them, and to look together with the regulator, in that case the European Commission, for the best solution. And only then the DMA will be really entering into force. Commission has to designate the gatekeeper, and then they have to start that regulatory dialogue, which should be a real dialogue where the Commission can also say, this, that doesn't work, that doesn't work. But then if they came to a conclusion, that then they get green light. And it's important that so many innovative businesses can keep on going without any danger of regulation, without any danger of intervention. But that has to be done on the basis of a higher transparency of these business models, because data are not for free in Europe. They have to be treated correctly. They have to be open markets. They have to be fair business models. And that's something where we really have to put a lot of more power behind. So to conclude quickly on the DSA, it's more about making clear that what is forbidden offline is also forbidden online, and that there are the procedural elements to make this happen between the member states and the companies, but also for the companies to act quickly on the relevant markets. And with the DMA, we have to make sure that we really get the markets into the center and impose on companies that are so big that they are a risk for the market to take a quick and fair look on the market and to act accordingly. And I think there are some elements that we will, let's say, see as a parallelism. In the DMA, I have been proposing that high-level expert group of digital regulators, where we want the member states to have a common look, although the application enforcement will be done at central level. And this is similar to the DSA, where the national regulators have, from the very beginning, a much more important role. But also here, we need some sort of cooperation control of the European Commission. And so we have really to make sure that we get it all done. And there is one element, this is advertising, because this is nonetheless one of the most important cash cows of this sector. It's one of the most important elements where they can reach out to users, that we get this market again much more transparent, and that those who invest into that market have to prove to those who pay what they did, and not just to say there were so many clicks and you have to pay that and finish, so that there is a real transparency and that there is a real market again. And I think on this, we are working very closely together also between DSA and DMA as on interoperability. And we want together to make sure that we get the best solution that is available at the moment. But I have to tell you that we also get the most reliable solution in courts, because we don't want this digital legislation to be jeopardized too quickly in court procedures.
Well, Vanessa, I know BEUC's position paper talked a lot about the potential for so-called gatekeepers to be able to circumvent rules using dark patterns and so on. So could you talk to me a little bit about that? I mean, this obviously is a big concern for you.
Yes, definitely. But maybe if I could, I would just like to pick up on something that Dr. Schwab said about regulatory dialogue. And certainly, I think in some cases, maybe not in all, there will be some need for dialogue. But I would argue that that need for dialogue is not just with the gatekeepers, but also there is a need to have a dialogue with other players in the market. Because we've seen, if we take an example for competition law, cases where there has been a finding of an infringement of competition law and then a remedy has been imposed, which is kind of equivalent to finding how to implement the DMA, or if necessary to enforce the DMA. We've seen that in cases where there has not been a dialogue with third parties, be it other businesses, for example, in the Google Android case, other search engines, and the remedy that was imposed didn't involve their input, we've seen that that didn't really work. And consequently, the remedy 3 years later has been adjusted, I think, following discussion with those entities. So, I mean, if you think about it, a gatekeeper who controls a market doesn't really have much of an incentive to make a market contestable. So I guess the gatekeeper's logical position is to do as little as possible to change its business model. But if we do want to make these markets contestable, it seems to me to be absolutely imperative that we listen to other players who can help the regulator, the Commission, decide how to implement, how to enforce the DMA. And I would extend that in cases where the effectiveness of the DMA will depend on how consumers react to how the DMA is implemented or enforcement decisions are taken, that consumers should also be consulted on these decisions. Now that would apply, and I think there are a number of amendments, I think also from Dr. Schwab himself, to Article 7, the regulatory dialogue provision. But if that principle is agreed, then it seems to me that it should also apply in other proceedings where, for example, in Article 25, the non-compliance decisions by the Commission or whoever is enforcing, that in those circumstances as well, if you're going to actually impose some kind of requirement, whether it's Article 25 or even Article 16, or if commitments are accepted under Article 23, that it's going to be critical to involve third parties to make sure you're getting both sides of the argument as the regulator, and then to take an informed decision. So that's a bit of a detour from the dark patterns, which I'll turn to now, but to me, it's a very important point in making the DMA effective. So if I now come back to the second important point of making the DMA effective, that would indeed be this issue of dark patterns. Now, where we come from on that is that we've seen in digital markets that dark patterns or sludge, or whatever term you want to use, the design of user interface basically can have quite a significant impact on how consumers behave when they interact with digital services. So our concern is that whereas the DMA focuses, for example, on prohibiting gatekeepers from putting technical barriers in the way of users switching applications, or enabling or preventing gatekeepers from, allowing gatekeepers to enable consumers, end users in the terminology of the DMA, to install or uninstall apps. All of those are kind of technical, but that is that's great that those provisions are in there. But you can quite easily get around technical barriers if you're a gatekeeper by using these design interface techniques and convincing consumers or end users, as I mentioned, to take decisions that are more in the interest of the gatekeeper rather than in the interests of the consumers, or indeed actually business users who are trying to get into the market. So in our view, Article 11, which is the anti-circumvention provision, really has to specifically say that these dark patterns techniques are unlawful under the anti-circumvention provision. And maybe just to give you some examples of those, and if you think about cookie banners, if you've got a big green button that says accept all cookies as an end user, or the choice is to not accept all cookies, you actually have to go into your browser settings. The chances are you're just going to press the green button if you're in a hurry. And the same would apply if you want to, say, change your search engine. If you have to go through multiple screens and do 15 clicks in order to change your search engine, are you really going to do that? Or, and maybe one perhaps closer to home, and you might want to comment on this as well, we've seen messages which nag users that Firefox browser drains your laptop battery, therefore don't use it, or pop-up windows suggesting you use Edge, for example. Although none of these things that I'm discussing, and you could look also at the way that Facebook designs its interface to make consumers choose Facebook's privacy configurations rather than allowing consumers to choose their own privacy configurations. And I could go on, there are endless examples of this, but the point of this is none of these are technical barriers and therefore wouldn't fall squarely within 6.1e of the DMA, but they are very efficient ways of potentially circumventing the DMA obligations in 5 and 6. And so for that reason, we think it's essential that Article 11 of the DMA clearly prohibits this. And I've seen actually that there are a number of amendments in the European Parliament, and now I also think in the Council that have recognised the importance of this, and indeed in the non-paper published recently by the Netherlands, France and Germany, which also referred to the importance of choice architecture and interface design. So I'm hopeful that this loophole, as I think was in the original proposal, will actually be closed and must be closed if we really want the DMA to be effective, not only for consumers, but also for businesses, as I said, because if consumers can't make choices for third-party business user suppliers of particular services or competitors to gatekeepers, then not only consumers lose, but we don't get the contestable markets that we're aiming for under the DMA.
Thank you, Vanessa. Let me remind the audience, of course, if you have questions for any of our panelists, do use the Q&A button at the bottom of the screen and I will get them to them. Mika, Vanessa there gave the example of Firefox. So tell me, for a challenger, independent browser, what does a good DMA look like?
Yeah, I think this is where there's a little bit of room for expansion. And I'll tell you from the perspective of the developers, and I'll speak not just on behalf of Firefox as a browser, but really this is the same experience by any of the common applications that you probably frequently use, your email client, your music client, your photo client, your document storage, voice assistant. These are all popular apps and services that people use. There are a diversity of these developers creating these products, and yet it's very hard to discover and set to default and use these software applications. And that's because of two things. One is the tactics that Vanessa referred to, these dark patterns, which are really focused on consumers to remain in the orbit of your gatekeepers. And so that is a specific thing. It's about consumers and their interaction with one-to-one with the gatekeeper. But then there's the gatekeeper interactions with developers. And this is where I really think that we're talking about app store rules that are discriminatory because they prefer the gatekeepers' preferences in terms of engines or technologies and just foreclose competitors. These are small techniques aimed at other developers that really prevent them from gaining market share. So for example, it is very difficult to set your choice of client, whether it's browser or email or whatever, music, as a default. You cannot do that. In fact, just to sort of underscore the importance of this point, iOS was released, I think, in 2007. And it wasn't until last year in 2020 that we first saw the ability to have a default. That means for 13 years, your default everything was whatever Apple told you it was. And even today, even though last year they made a change, so now you can set an alternative browser, such as Firefox or an alternative email client as a default, you still can't do that for a variety of other software products. And so that's where when we're talking about what is the DMA trying to achieve, we want contestable markets, we want fair business models. That in itself is not fair. It's very discriminatory. On Android, as another example, another operating system, you have had the ability to set to default, but that's selective. So even if you select your default for certain applications, you may open deep links, and those will not necessarily open in your preference. And so this is where the DMA, I hope, goes further and addresses it both for developers through these discriminatory tactics and self-preferencing, and also on the consumer side by really clarifying that adverse patterns are really not the way to go.
Well, Mika, let me stay with you with a follow-up question from our audience, pointing out that one of the features of modern smartphones is the combination of hardware, software, and services. So how can interoperability foster competition in areas where the applications need a mixture of all these functionalities?
Right. So again, I'll just go back to the internet as a starting point should be interoperable. You should be able to access a website from any browser and on any operating system. You should be able to use whatever, like if you prefer Spotify. Why is it that you can't use Spotify on your Apple home device or on your Google home device or on X operating system? This is where interoperability would help that. But at the other side of that is there are standards organizations that exist, and it is common. This is how the internet has developed to a place where we can have this call with each other. But what we see is behaviors by gatekeepers where they choose not to comply with standards or to do their own thing, which is perhaps better off for their particular product suite, but then it causes a great disadvantage for everyone else. And so a classic example of that is video conferencing. So here we all are, we're on Zoom. I don't know what browsers or operating systems you are all on, and it shouldn't matter. We should be able to meet here and have a conversation. But you can't actually do that. That's why you have probably seen, if you're trying to connect on Slack to have an audio call, if you're on Microsoft Teams, it will fail depending on what browser you're on and what operating system you're on. And that goes back to the question, hardware, software, this is governed by standards. And this is where gatekeeper behavior to not comply with standards, not test and release, not quickly and timely solve these problems, because time is of essence. If a user wants to do something and they can't, they've already switched. And that's where interoperability, standards compliance can really help to create an open and fair market.
Thank you, Mika. Another question from our audience, Andres, this one specifically for you, asking what does the Parliament intend to do with requirements for app stores interoperability? The issue of app stores has already been raised, but if you could answer that, it would be great.
I mean, obviously, app stores are gatekeepers in the pure term, as you could imagine. And therefore, there has to be some sort of fair behavior that is foreseen. There has already been the example of Spotify. I mean, if you know through your app store how consumers, how users are behaving, and you take that higher level of understanding of the whole system to put your own services ahead of the others, this is unfair competition. Secondly, obviously, these app stores have to be open. I don't say that they have to be open to all products, because that app stores have also a responsibility to look for privacy and for cybersecurity is obvious, but there have to be very clear arguments why they are banning specific forms of, from their point of view, unsafe or unprotected apps. So there is a whole sort of reflections around that the Commission has to make sure that app stores are open and can be used for all market players as tools for innovation in the interest of the users and the consumers. If you allow me, Jennifer, there have been some other comments that I would like to come on. These dark patterns, for sure, there is the question in relation to Article 11, how to make sure that we catch all the uncompetitive behaviors that should be catched there with that circumvention clause. You have seen probably that I have been changing even the circumvention clause at a higher level in the directives, in the regulation, so that it's capturing much more, even if it doesn't mention dark patterns. But the circumvention clause is now a clause that is applicable to everything what could jeopardize the deals or the goals that are outlined in Articles 5 and 6. And I believe, but I will look again on it, that this is a tool which works very well. Leaving aside, Vanessa, that for sure third parties, users, consumers, people that have knowledge with it should be heard at the Commission, I can tell you that I'm 100% sure that they will be included, because the Commission urgently needs their input. But if you want that to be outlined again in some sort of recital, that is our pleasure. I'm sure that all colleagues will agree to that. For us, it's a no-brainer, this. But if you feel that that should be written there, I will also take due notice of it. I just would like to tell you, to conclude that intervention here, Jennifer, I have just read that the Chinese are again now getting much tougher and want to break up specific services of their gatekeepers. I don't comment on it, but I tell to you very clearly that here and on the other side of the Atlantic, we agree that what we do here is to make sure that markets operate again openly, freely, transparently. Nothing else and nothing more. We are here not to put specific services aside to control them better. We are here to keep the market open, to give everyone a chance to make the most innovative idea a reality for all consumers. That's the American dream, much further, by the way, than the European one. And that idea has to be in the internet again, with notwithstanding app stores, notwithstanding gatekeepers and whatever. But we have no other idea behind. And I think this is something that links us with the US. And I think this is also links us with a lot of players. So at the moment, we are not so much sitting in the committee looking, saying that we know better than the others. I think all colleagues have the same idea, to look for open and free markets. And I think that this is even the aim in the US. And if you have good ideas, and I have already told you some of them that were mentioned, we are taking them up, promised. But what we don't want to do is now to somehow make a sketch about how the internet and how the app store reality should look like in the next 5 years, and that politicians go now through and say, this has to be done like that. And that will not work from my point of view. It's an open economy. It's a social market economy, and we have to look for the rules that are open for everyone. But how companies in the end do it, that's an issue for the economy and not for politicians. And I don't believe that we know better how social media has to look alike. if there are videos in the future more used than pictures, and if there are sound is much more used than in the past. We don't know that, and we should give the market a chance, but only a fair and an open market.
Thank you for that. Let me see, Vanessa, did you want to jump in and respond to any points you've heard so far before I take some more audience questions?
Happy to jump in. I'm very happy to hear that the rapporteur will look again at the dark patterns in Article 30. That's great news. And we're also very happy, this may be a subject that's come up incidentally, but not directly, but the idea of making sure that voice assistant services are also clearly falling within the scope of the DMA. I think, again, that's something that now people have suggested, including Dr. Schwab, which is great, because from our perspective, voice assistants, or there is evidence already in both, I think on both sides of the Atlantic, of voice assistants raising similar types of issues to the issues that are covered in Articles 5 and 6 of the DMA. So I think in terms of future-proofing the DMA, this will be important to make sure that they are included, because of the potential future use of these devices. I think that future use will be greater than it is today. And in voice assistants, by definition, consumers can't see alternatives. Therefore, it's important that the kind of neutrality, or the not preempting the consumer choice that was mentioned by previous speakers, is applied in those cases as well. There is one other procedural aspect I'd like to raise, but I think that will take us in a different direction. So I'll pause on that and come back to that later, hopefully.
Thank you, Vanessa. Yes, time is rapidly getting away from us. So I'm going to ask Mika about core platform services and the possibility of extending that to include web browsers and what you make of that. And I'm going to then tie that into a question to Andreas afterwards from our audience member.
Right. So I actually think that, I'm actually a product lawyer. I've spent the last 9 years of my life working on products in mobile operating systems and app stores and video conferencing and browsers. And so at the end of the day, as a product lawyer, I think there is difficulty from the highest level to both regulate to create open markets, but then not regulate so deeply that you control a product, because this becomes very difficult. This then actually clamps down on innovation and what products and what a product knows best, how its engagement is with users. And so, you might find it surprising, but I don't understand what the purpose would be to expand core platform services to include browsers. And the reason is, my question is, what is the problem you're trying to solve? If you know the problem that you're trying to solve, then what are the things that are needed to solve that problem? I don't believe that, I know there's a lot of problems with browser competition. And like I said, I think that extends actually beyond browsers to a whole host of sort of apps and services that are very commonly used. And this includes the list that I mentioned, not just voice assistants, but music, photos, application storage, like photos and documents. And I'm not sure where including them on a list of core platform services, I don't think that solves the competition problems. I think rather addressing it through clarifying the discrimination tactics, so that gatekeepers cannot preference their own affiliated apps vis-a-vis those applications, clarifying that gatekeepers cannot engage in dark patterns to continue to keep consumers in their affiliated versions. I think this would actually go much farther than just adding to a list. And also there, my question is, well, why just browsers? There's a whole host of other software applications that are very critical. And I'm not sure, what happens to them. I worry about that.
Thank you, Mika. Well, Andreas, let me ask you then a question from our audience is asking, what's your position on the extending the prohibition of bundling beyond core platform services to the rest of other services provided by a gatekeeper?
Well, I mean, the DMA is not a tool that in the future will be unchanged. We will give the European Commission quite a lot of powers to adapt this tool to new situations where we will be living exactly the old realities. So the core platform services list is an open list. It's an open list that is defined in some areas, but in the end, all online intermediation service is covered. And thereby the European Commission has the power to say also the service X will be considered as an online intermediation service, because the list that is there is not an exhaustive list, it's an open list. Therefore, we don't have to discuss too much about what other CPS should be there. And if there are, if it's an open list, then it's also clear that the European Commission will also, on the question that has been asked, able to answer or to include other services. For sure, they have to be CPS. They have to have a certain core platform service quality. But if they have, then they will be considered a CPS, even if they are not yet in the list that is there. And I think this is a bit the danger, but also the challenge and the opportunity for all of us. I think we have to do with very innovative and very fastly changing markets. And I'm sure that even with BOIC, it's sometimes difficult to follow up on all the developments. So if we are not open-minded and try to use this law as a basic law and not as a specialized law that is already foreseeing everything, we will fail. And therefore, the behavioral remedies that we will facilitate for the Commission to be used, also with an aim of allowing interoperability as one element for the gatekeepers to be implemented, but also with structural measures for the European Commission we will facilitate that as well. We will give the Commission more responsibility on this, on making the European digital single market an open and fair market. Obviously, this is a high level of responsibility. And for the lawmaker, it's always difficult to pass that power to someone else, because we believe that we would be the best to do so. But it's an executive task. We cannot disagree on this. And therefore, it's up to us as a lawmaker and as a parliament, but also up to BOIC and others to oversee what the Commission is doing with it, how the Commission is using its powers. And we believe that we give the Commission quite extensive and flexible powers, but they are proportionate, they are controlled. And with these powers, the Commission has to do the right stuff. And if they don't, we will come back and we will change the law. That's the philosophy behind. And I hope that we can convince everyone who is here and out there that this is the best approach that we can do at the moment. Maybe in 2 years, maybe in 10 years, we will be saying, no, we have to change it again. But for the time being, we believe together that this is the best approach that we can use, even though it's giving quite an extensive power, quite an intensive power to the European Commission as an executive branch of the European Union, which is controlled by the college principle, which is controlled by the European Parliament and by the European Court of Justice, and ultimately governed by the rule of law and proportionality, to be very clear.
Vanessa, let me bring you in now. You wanted to make a comment that was going to spiral us off in another direction, I think. What was that?
It's linked into what Dr. Schwab has just said. We do think that enforcement is going to be a really important point, and it needs to be done properly by the European Commission. It shouldn't go. The law shouldn't allow us to go too far, but also it should allow us to go far enough. And maybe there are two areas where we don't yet go far enough, in my view, and it links into the structural remedy type issues that Dr. Schwab was talking about. Under Article 25 of the current DMA, which is an article that allows the European Commission to take non-compliance decisions, what the Commission can currently, under the proposal, do is to make a cease and desist order, which arguably does not allow a structural remedy, even though at this point in time there is a finding of the breach of the law. So one thing that we would suggest is that it actually might be important to include in Article 25 the ability to impose behavioural or structural remedies, in particular behavioural remedies at this stage. At the moment, the way that the DMA is set up, it only allows that type of remedy explicitly if there's a systematic non-compliance by the gatekeeper. But that could take multiple years to establish, and in fast-moving markets, lots of damage can be done in multiple years. So maybe this is one area where there still needs to be more done, so that if there is a breach of the law established, subject to the control of the courts, as was mentioned, that actually there is sufficient powers to actually to right that wrong, rather than just tell a gatekeeper to stop doing it. Because if then the gatekeeper tries another thing which is also not in compliance with the law, in the meantime, markets aren't contestable, they're not fair, and consumers and competing businesses and business users suffer. And then maybe one last point, just also in relation to enforcement. There's discussion as to, in addition to the enforcement by the European Commission, should it be possible for people to enforce the DMA in actions in national courts? And we would argue, yes, it should, subject to ensuring uniform and application of the law. But if you're going to allow, say, businesses to enforce the DMA, their rights under the DMA in court, the same should apply to consumers. Now, an individual consumer trying to take on the tech giants is an illusion in a court, but what is more realistic is would be the ability to bring representative action, so collective redress, to try to make sure that the gatekeepers are complying with the law. That's currently not foreseen in the draft, but we could fix that by adding the DMA to the annex of the Representative Actions Directive, which was recently adopted by the Parliament and the Council, which would then be another way to try to deter gatekeepers from breaching the rules, to the benefit not only of consumers, but also of the businesses, the business users who should be able to benefit from what the DMA is trying to achieve. So those are maybe two, subject always to the control of the courts, but two further ways that we could maybe improve the current proposal of the DMA to make sure not only that it's a great law on paper, but actually it works. It actually works in practice.
Thank you, Vanessa. I was actually going to ask about enforcement, so that's good. And I think I can hear the echo of GDPR in the ghost behind what you're suggesting there. Andreas, would you like to react to those suggestions?
Well, I mean, obviously, the big headlines, they are always in agreement. When you go to the details, it gets a bit more difficult. And then it matters also the question how to make this law something that can stand in every respect in court and can be implemented quickly and finds the right majorities and is tough enough to be enforced. Therefore, I have been myself the rapporteur of the European Parliament for the Actions for Damages Directive, which has been creating possibilities for consumers to go for actions on the on competition cases. But here all eyes, there was the principle that the best is that the authority that has the power and also the manpower and the resources does the job, and on the basis of the result, users and consumers go in and get back what they have been unfairly losing. And I think that principle is very much valid also for the DMA. And for that reason, I have been proposing in my amendments myself that national courts should also be open to go for the monitoring of the principles in Articles 5 and 6 of gatekeepers, so that national users, consumers, and businesses can go for it. From my point of view, the collective redress directive is not needed to be changed because there is already in national courts standing. And therefore, it's important for member states to make a decision where they want to go. But if the courts at national level are competent, as I have been proposing myself, there is the door opened. It's also true, and Vanessa was smart enough to mention it, that there is a defragmentation risk. And we don't want the European single market being added here with such risks. I believe that we have really to make sure that not only in the enforcement area, but also in the courts and decisions area, we have to make sure that there is a one uniform approach, not in every cent, but in general. And therefore, that has to be respected. But as I told you, there is no doubt that there has to be a standing in courts also on the rights under Article 5 and 6, because that makes the tool much more efficient and makes it also much more dangerous for the gatekeepers not to abide by the law. However, as I said, I have just been reading the case from China with Alibaba, I believe, and that's unique in the Western world, the business logic of the gatekeepers has most of all been shareholder driven. And the investors in the US, they are very smart, and they have been always saying to these companies, you go for as much as you can. But I believe very strongly, if we tell them, listen, this is forbidden in future, they will stick to it. I don't believe that they behave in Europe like in the Wild West if we give them clear rules that we have been failing so far to give them under competition policy. And now with that single market tool, I believe that we can do it. And therefore, we should work it out together, and we should try to find the best solutions. That proposal of the courts and the standing there is already in my report. Actions for damages might be difficult because they are applying only to competition policy, and here we are in the single market area. Therefore, there will be the national court system to be applied. And there we have already done the collective redress proposal. And therefore, I believe that it's already covered, but for sure I can have another look into it.
Thank you, Andreas. Mika, in terms of, if you like, making the law robust from an enforcement perspective, I know you've worked in antitrust and regulatory issues in other jurisdictions. Is there something we can learn from any recent cases or from other jurisdictions with regard to this? And I also have a question here from David Pazzodi, asking about the ripple effect of the DMA, and is there a specific dialogue with US lawmakers?
Yeah, well, we just saw on Friday in the US, the Epic versus Apple case, the federal district court judge handed down their decision. And, they found for most points for Apple, but the reason for that was also because under existing law, the judge could not find that Apple was engaging in anti-competitive behavior necessarily, but certainly left room that this is something that the other competition agencies could take up under their interpretation of the law, and this is where it comes back to the ripple effect, the need for reformed law, because existing competition laws, I don't think the way they were created really adapts to the digital tech that we have today. So that's where I think, in particular, right now, we don't have any. South Korea recently passed, actually, I think also last week, a law in the App Store context for payment services. But otherwise, on the horizon, I don't see anything that's immediate. And again, in competition law, this is really, time is of essence. In fact, all of these services that we're talking about have been ongoing. So there's already consumers' behaviors have changed, people have adapted. And so we need something fast. We need something that is quick. And we need something that once the basic law is passed, it can really, enforcers can start to run with it. And I'll just respond to the comment on remedies. I think this is where remedies are really important. And actually, I'll take Dr. Schwab up on the proposal to clarify in the proposal that when remedies are created, there will be consultation, not just with the gatekeepers, but with other stakeholders, including consumer groups and developers, because that actually hasn't necessarily happened in other cases. And that's why where we see, choice screens, it's a favorite remedy that a lot of people pitch, but the choice screens have not been effective. And I think that's for a variety of reasons. We can have a whole other panel on that. And that's where I would hope remedies are, there with consultation and dialogue, and also that the basic law doesn't go and include remedies, because that also then hamstrings the ability of the basic law to achieve what it needs to do.
Andreas.
No, I just would like to support Mika, because she has very nicely explained why lobbyism can also be something good. I tell you very clearly, if I hadn't spoken so much to companies, to smaller companies, about their negative consequences of the gatekeepers' behavior, I wouldn't know what I know. So your call, Mika, that we have to speak out to all market players to understand what's happening and what's going on there, this is amazing. And this should be a call to get better information about what the reality in the market is, but not only for the European Commission to listen to Berg and to other stakeholders that have to lobby the consumer approach, but also to companies. I have also had a very interesting exchange with one of the gatekeepers where in the end I said, you are lying, you go out now, because I have asked for questions that have never been satisfactorily answered. So talking is an advantage in that area. And I'm very grateful to you that you ask for it. And I think this should be a task for all politicians that deal with that issues, to speak out to as many specialists as you are, to as many consumer associations, and to as many others, to understand what behaviors are jeopardizing the freedom and the openness of our market and how we can create remedies to this. This is for sure not easy, and there are plenty of problems, but I'm very grateful that you have been making that clear, Mikhail.
Thank you, Andreas. I'm just going to ask, as we are just at our final minute, quick final word from you. How feasible is the timeline? What can we expect when?
Well, I mean, we want this to be a law that is effective from the 1st of January 2024. 23, sorry for this, 23. And to get there next year, this has to be fixed. And therefore, we have to vote in December because we need some time to start to discuss with the council. And for sure, this is quite a challenge, but we are working very hard to get there. And I know also that colleagues are very strongly committed to make it happen. And for sure, we will try the best. But a professor once has told me, take care, Andreas, because if you always try to improve, then you will once get the situation where you discover that the better is the enemy of the good. And so we have also to get on with it, even though for sure there will in the end be some elements that we will not be perfectly finding solutions. But I agree very much with Vice President Vestager. We have to make sure that we can start somewhere seriously instead of discussing forever about everything without starting anywhere. And that's what we want to do, but we don't do it superficially by saying, now let's rush it and we have something. We do it seriously. We discuss a lot with stakeholders. We speak to companies, we speak to consumers, we speak to users, we speak a lot. We keep an open market approach. This is not about consumers. It's about the possibility for consumers to use better this market if it's an open and fair market. That's the principle behind. And I'm very grateful that all stakeholders agree to this and we don't make general discussions about what is more important. No, the market is important to all of us because it gives the choice to consumers, to users. And this choice is the key that we want to defend. And it has to be an open and fair and a democratic choice. And I think we will find a solution to this. And if you follow us constructively, it will be even easier. Thank you so much.
Thank you, Andreas, and thank you for this discussion today. It's been great. Vanessa, a final word from you to the lawmakers, to Andreas, to any other lawmakers, or even the council in the future.
Thanks. Keep going as you're going now, and we fully support what Andreas said about making a reality on the 1st of January 2023. So even if it's not perfect, if it's sound, we would very much welcome it. It is time for action, not talking anymore.
Thank you. And Mika, obviously the ripples will be felt across the Atlantic as well. Any final thoughts from you?
Agreed. Keep going. I'm really appreciative of the speed. On behalf of developers, I think that is really important. And on behalf of, as I said, don't forget the internet. At the end of the day, this is about the internet, about consumers, and about developers. So I'm really glad that those three groups are being thought of in this process.
Thank you. Well, thank you all very much. Thank you to our audience for the questions. There's another very good question that just came in a little bit too late for me to get to it because we only have 1 hour and it's never enough for these Mozilla Mornings discussions, but I'm sure there'll be another one along soon. So please do keep following online, do stay interested, and do share your thoughts on this with your colleagues and friends. Thank you all very much for your thoughts, and thank you to Mozilla for organizing.